Good morning, good afternoon, wherever you're tuning in from. Welcome to Lecture 4 of the JGLS Insolvency Law Lecture Series. Today we're going to talk about third-party funding in insolvency and talk specifically from the perspective of Cayman Islands, with our speaker today being a global head of dispute resolution and a renowned insolvency practitioner in this, who has advised the government of Cayman Islands on third-party funding arrangements as well. I know we live in a Google generation, so I'm going to keep the bio short because the accolades and the information can keep us here all day otherwise. Our speaker for today is Mark Kish, who is the partner and global head of dispute resolution of Auger. He's a fellow of Insol International and specializes in contentious restructuring and insolvency proceedings, commercial litigation, funds disputes, and financial service claims involving fraud and breach of duty. Now, a lot of my teaching for my students who are logging in and for people, those who know me, is multidisciplinary, and I can't think of a better speaker to talk about third-party funding in specific, because Mark is a part of Auger's multidisciplinary restructuring and corporate recovery and PE team. Now, we've covered legislation, which we're going to talk about. We've covered practice, which we're going to talk about. And his achievements, very briefly, include advising on schemes of arrangement, restructuring bond debt and other assets, along with bringing and defending large-scale fraud and asset tracing claims on behalf of liquidation estates. Today, we're going to talk about something that has very little information and traction in India, particularly given globalization. We're looking at cross-border insolvency and the interplay between Cayman and onshore restructurings and insolvency proceedings, which Mark has a host of experience of. It is extremely crucial for us to talk about third-party funding arrangements and where they fit in insolvency and restructurings, since India presently is looking at a lot of conversation around different kinds of restructuring within its insolvency law and also outside its insolvency law. So without further ado, Mark, I want to start with the explanation of third-party funding in litigation and restructuring and what refinancing means, where it comes into play. And we're very excited to have you on board, and over to you.
Thank you, Ashana. It's a real privilege to be here. And thank you for that very kind introduction. Litigation funding is really a hot topic at the moment. And as a result of that, I think it's really important that people understand how it works in practice, particularly for insolvency practitioners and for liquidators of companies. I'm going to speak from a Cayman perspective, but it is generally true, I think, of common law jurisdictions around the world. But hopefully I can give you a feel for how this works in practice. So when a company goes into insolvency or even a formal process like a liquidation, very often the main assets that it has are claims. You know, they're not tangible assets that are easy to sell. Otherwise, it probably wouldn't be in insolvency in the first place. And the person charged with bringing that company around or maximizing the returns for the claims that it has needs to do that in as efficient way as possible. And very often that person, whether it's a liquidator, provisional liquidator, we can come on to what those differences are, will look to what assets the company has to be able to prosecute those claims. Litigation is expensive, as we all know. And usually in this kind of scenario, the company doesn't have cash in the bank to be able to bankroll the litigation claims that will in turn, it hopes, bring more proceeds into the liquidation estate. And so the liquidator or potentially the directors, if it's not yet in liquidation, need to look for funding somewhere. And the first thing they'll do, of course, is to reach out to the stakeholders of the company, the people who are already invested one way or another in this company and who know the company better than anyone else. So they'll ask the creditors, will you put up some more money to be able to get something back? In return, we'll give you priority over the other creditors for repayment of your loan. Or potentially in a solvent scenario, shareholders may be willing to put money in, even in an insolvent scenario, if they're confident that the assets that they have are worth more than the debt that the company owes, and so there'll still be a return after repaying the creditors to the shareholders. So that's the first port of call. But if that doesn't work, then what do the liquidators do? Well, the answer is they have to look to third-party funding. And that's really where funding comes into its own. So the idea of third-party funding is slightly different to where a stakeholder, an existing creditor or shareholder will fund, because it's not just a loan with an interest rate. Almost always, a funder will look to recoup its spending through a percentage of the proceeds of the claims. So, if the company owes $50 million, but it has claims worth 100, it may be prepared to give 20 or 30% of the proceeds to the funder, because it will still have enough left over to pay its debts and be able to resume its business and pay something onto shareholders. So that's the basic premise of funding in the context of litigation claims. It's slightly different in a restructuring scenario. And the reason I say that is that very often companies, depending on what type of company you're talking about, so you may well be looking at oil and gas or other types of companies where there are sunk costs for infrastructure, for plant and equipment, or there are other assets that are very difficult to sell. There may be litigation claims, but they're actually what you're looking to leverage here is the future earning potential of the company. Now, a really good example of that is in the energy space, where you may have an exploration company, for example, gas exploration, where there's a huge amount of upfront cost. Getting the equipment, paying for the infrastructure, paying for the people to put in the time to actually get in the ground and find those resources. And the ability to sell and make a profit on those resources comes much, much later in the piece. So huge earning potential should interest the third-party funder. So how do you go about doing that? Well, you can ask for simple refinancing from your existing lenders. Can we renew our financing arrangements? If that doesn't work, people who are already creditors may be willing to convert debt for equity. And so we talk about debt for equity swaps, where somebody will say, well, I'll give up my right to be paid as a creditor for the long-term gains that I think this company has down the line, or simply a cash injection for equity. But where the funding comes in, if you can't succeed in any of those from existing stakeholders, that the funder will come in and say, well, I will take a percentage, again, for a percentage of the proceeds of sale of these assets in return for helping you in lots of different ways. And the funding is going to be important in various ways, because you need to pay your staff. You need to pay for raw materials. You need to continue to pay your service providers. And you can imagine the huge number of costs that kind of company will have on a monthly basis. You will probably also, by this stage, need to pay professionals' fees, whether that's accountants or lawyers, people who've had to get involved because of the insolvency. You may need to pay for court applications to get approval to be able to go ahead with the restructuring. And if you have professionals who are coming in, insolvency practitioners, you need to pay their fees as well. So all of these things need to work. But the important thing is that even when those who are closest to the company are not willing to continue to put their hand in their pocket, third parties can come to the rescue.
Thanks for that, Mark. One of the things that has been very curious in India is the fact that the trust factor in contract, sort of is a deterrent in terms of having any related parties or promoters involved in a restructuring process. And I think in terms of what you just explained to us in terms of what third-party funding is, it'll be very useful perhaps for a country like India to have that kind of pool. But of course, the question is whether there's enough money which a third-party funder has to be able to fund an insolvency or a stressed asset setup. Now, I want to understand, and I know that the audience also wants to understand how a localized law can respond to a third-party funding arrangement. Because yes, we have private M&A or regulated M&A, as we like to call the insolvency, or I like to call the insolvency process in India. In the Cayman Islands, though, the thought process and the structure is quite different as far as funding structures go. And we do look globally at Cayman Islands because that's where fund structurings and a lot of restructuring methods and mechanisms come from. So what is the insolvency regime in the Cayman Islands, and how is third-party funding used in insolvencies?
Yeah, thank you. It's a really good question, and the framework is really, really important to this. So the framework, the legal framework in Cayman is designed to do two things, really. One, to bring the professional experience and, of course, the funding, if necessary, to the company in the most efficient way possible. And two, to give the creditors the protection that they deserve from the potential for fraud or unscrupulous actors, or even just for a scheme that wasn't very well thought out and for no one's through no one's fault just doesn't succeed. And so the way we do that is on insolvency, there is a mechanism for bringing in professionals in the form of insolvency practitioners. And very often what you'll see is that if there is no consensual arrangement that can be agreed with the stakeholders, then a creditor can file for a winding up. And assuming that it can show that the company is unable to pay its debts as they fall due, then the court will, in almost all circumstances, that does have some discretion, will make a winding up order. And that's a terminal process for the company where you bring in third-party insolvency practitioners, and their mandate is to realize the assets of the company, pay off its debts, and if there's any surplus, pay those to shareholders. In terms of restructuring, though, we have another process in Cayman which is designed to work alongside that, and we call that provisional liquidation. Now, that may change, the terminology may change with some planned amendments to our law in due course, but the principle is the same. This is a process within a process. So you may still have your petition to wind up the company, but before it gets to the hearing of the petition and the appointment of the liquidators, the company itself, or potentially other interested parties, can apply to say, wait, this is not a company that should be wound up. We have a potential here to restructure in a way that benefits everyone. We can pay off the debt and we can carry on about our business. And the company will need to present a plan of restructuring to the court, and it will need to put forward insolvency practitioners who are willing to do that job. Now, they may be different to the original nominees for liquidation, or they could be the same. The important thing is that the court needs to be persuaded at that early stage, usually based on financial statements and a proper understanding of the way the company operates and its debt and liabilities, that it's a viable prospect. And so what you will see is the court saying, okay, well, I will appoint provisional liquidators for a specified period, say 3 months. And I want you in those 3 months to look into the viability of the restructuring and report back to me. And so the parties go back before the court, and the liquidators may say, well, I've spoken to the directors, I've spoken to the lenders, I've looked at possible purchases of assets, and so I've explored different possible refinancings or restructurings. And I think this is worth a look. Give me 6 months or a year, And so this is an iterative process. You know, the creditors or the petitioner is free at any time to come back to the court and say enough is enough. But the liquidators will otherwise, the provisional liquidators will otherwise say, no, this is worth continuing. And they are crucially officers of the court. They are appointed with their primary duties to the court. And so in that capacity, the court will listen to its officers and say, well, okay, I'm going to allow a bit more time. But at all times, the court is doing this and exercising its discretion in the best interests of the creditors. So it has those creditors in mind. And if at any stage it thinks that this is throwing good money after bad, then it will stop with a view to maximizing return to creditors at that stage. And so that's really how it works. It's not always straightforward. That's, you know, with a single company, that can be relatively straightforward. When it gets into a group scenario, it can become more complicated because the principles of corporate personality, respecting each company's own asset and liability position, is extremely important. And so it's not always as simple as having a liquidator appointed at the top co of a structure and being able to require assets to be funneled up from all of the other companies. It needs to first respect the obligations of all of those companies at the different levels. And so it will need to kind of think carefully about whether there will end up be enough money coming back up the structure to pay the debts of the top co, and of course whether funding is needed at any stage of that process.
So I know that you have a case study for us, and let's sort of dive into that, because it's very critical for the audience and for us to kind of understand how impartial, transparent, and also within a regulated framework does a third-party funding arrangement work. That it is not something that's under the table, that is actually something that is regulated and sort of structured and has a business purpose, which is very crucial to any kind of third-party structure. So let's sort of get into the case study then, Mark, and talk a little bit about that.
Sure. Let me see if I can share my screen with you. So hopefully you can see a diagram now.
Yes, all good.
Great. Now, this is based on a case that I did within the last 12 months. I've obviously kind of put in some different names, but this is more or less the same structure, not quite exactly the same. But what you have broadly speaking here are, so this is a gas exploration group, and here you have the operating companies. You have a similar setup over here with respect to a different field, but we were focusing on these. And you have lenders here in the form of bondholders and note holders, both of whom finance the topco, this company, and in return they received security in the form of guarantees, which you can see here. Obviously, the guarantees are given by one of the operating companies because that's where the money is flowing through at the initial stages as soon as it does. But they also had an equitable share mortgage, which you can see here in return, or the bondholders did in return for the loan that they made. So I hope, broadly speaking, that's clear. Now, the lenders weren't repaid in accordance with the terms of the bonds and the notes. And so the company, when I say the company, this was the company in question, the topco, amassed significant debts. Now, as we've discussed, that is not unusual in this kind of a structure, because there is a huge amount of upfront investment, and it's only when that company becomes profitable at a much later stage that debts are typically repaid in full. However, for reasons that I won't go into at this stage, that by the time the bonds and the notes had matured, the company wasn't in a position to repay. There had been some discussion the lenders had become impatient, and so they wanted to push ahead with a winding up. And so what they did was that they filed a petition at this level for the winding up of this topco. And as we've discussed, there is a process in Cayman which allows the company to say, no, no, come on, we are viable here, we just need more time. And so what happened was that the topco applied in the context within that process of the petition to appoint provisional liquidators. And provisional liquidators were appointed at this level, and they were given 3 months to explore the viability of a restructuring proposal. And they wanted to do that either through a refinancing with these guys or with another lender, or through the sale of assets. And the assets in question would be the ones in the green box here. In the meantime, and you'll gather that there was by now a slightly contentious atmosphere because the bondholders were petitioning to wind up. That's what they wanted. The company was resisting. But the bondholders had the benefit of this equitable share mortgage. And so they appointed receivers over these shares in the next company down in the structure. And once they had done so, those receivers were able to exercise the rights that went along with those shares. In particular, they were able to appoint directors over this company. And once in control of this company, they were able to appoint directors further down the structure. This is what's known as a board cascade. So now you have a situation where you have independent provisional liquidators who are insolvency practitioners, who are officers of the court, appointed here to explore a restructuring. But the people you have controlling the companies who would sell the assets are actually resisting because they are more closely aligned with the people who appointed them, arguably, than with the best interests of these companies. And so they are resisting, or at least being cautious about the prospects of a sale. The important point here is that it's not the same people who are in charge up here. And so there is obviously room for reasonable minds to differ, and that's what happened in this case. So broadly speaking, the provisional liquidators wanted to sell the assets in the green box in order to repay the debts, and in doing so, fund future projects for the group, such as these over here. The PL's view was that they could sell these assets for sufficient value to repay all of these creditors and pay the legal expenses by now incurred by the liquidators and the company, and then to be able to continue. And so on paper, it looked like quite a straightforward prospect. What they needed, though, because they weren't able to obtain further funding from the lenders, and because there wasn't sufficient money already in the company, was that they needed to approach third-party funders. Now, the funders aren't represented on this diagram, but you'll appreciate that what the funders were looking at were several factors that they needed to be satisfied before they paid out quite a lot of money to be able to do this job. They need to be satisfied of the likelihood of the sale of these assets, and so there are potential third-party purchasers here. They needed to be satisfied of the expected sale price, because that is what would determine whether they would get paid and how much. The likelihood of obtaining court approval, whether the funder would be prioritized ahead of these guarantees, and whether there would be, I should say, whether there are any challenges being made by the creditors who didn't want the project to go ahead, and also whether any money would flow back up from here, having paid the funder and having paid the guarantees, would flow back up to this company and then the topco, so as to be able to repay the professional fees incurred by this entity. And that's what I mean when I say that it's important to understand corporate personality, which is strictly observed in the Cayman Islands, because at each stage of this process, it was really important to be able to look at the asset and liability position of every company in order to be able to gauge whether this project will be successful for all concerned, including whether the liquidators themselves and service providers would get paid at this level, and potentially whether, having repaid everyone, there would be surplus to go up to the shareholders. And so that is a one example of a fairly involved. I haven't put everything down there, but that is one example of a fairly involved structure where conversations were ongoing with third-party funders with a view to trying to get comfortable and satisfy all of those different pieces of the puzzle.
That's a very interesting sort of takeaway, Mark. That is the prioritization of the funder over a guarantor, or like a rejig of the prioritization of what is typically in India known as a waterfall, or a priority of claims, as is the internationally used common terminology. Now, one aspect that really is a takeaway, and I want to mention that here, is the aspect of the PL and the lawyer who's involved in this case, who makes an approach for the third-party funding, right? And the identification of the third-party funder being done through a bid, or is it confidential, or is it advertised? That would be a very interesting question to generally understand the process of third-party funding. But let me take a step ahead and ask a question on roadblocks instead. So, what are the most practical concerns? Because, like you and I were talking, there's nothing on third-party funding in India, perhaps with the view of not regulating anything which involves funding, and not bringing it to the forefront of the limelight, and just let it happen in the regular course of a funding arrangement, or M&A, or a PE transaction. So what are the roadblocks with the structure that exists, like we've just seen in the Casco setup, the Holdco and Casco setup in Cayman Islands? Also, in terms of liquidation, what happens there? Is liquidation a deterrence, and is funding more likely to happen in group insolvencies?
Yeah, thank you. You raised some good points. And I think in answer to your question, that it's very important to go back to what I said about the court sanction process. So in the scenario that I was talking about, you had the provisional liquidators needing to go to the court and say, look, this is something we'd like to do. And I'll actually bring up the chart again, if I may, because I think it's going to be important to explain this by reference to diagram. So you have the provisional liquidators appointed here, but actually now, because of where the assets are to be sold and where the immediate proceeds will be generated in the structure, it's going to be necessary to have some degree of buy-in from these companies. And so that's your first roadblock. If these companies, who are now under the management of the receivers, do not agree that it is in their best interests to allow this funding process to proceed, then you may have opposition in the court hearing and people putting counter proposals. And so what we decided to do in this case was, at least the proposal was to have, because this is also a Cayman company, an application to appoint the same provisional liquidators as were appointed to this company, And by doing that, we would have a consistency of approach between the various debtors in the structure. So between the topco who had accepted the loan and provided security, and also this entity which was not the direct beneficiary of the loan, but had provided security in the form of guarantees and would have the primary obligations from the proceeds of any funding and indeed of any asset sale. And so it was going to be important to be able to secure the cooperation of that company. Now that would have to be done through a slightly different process to the one we just described, but similarly by an application made by creditors of this company to the court to say that we support what the provisional liquidators are doing, and we would like you to appoint provisional liquidators. Now, in this scenario, we have the reverse of what happened up here, because here the petitioner was saying we want to wind up, and the company was saying please give us a chance to restructure. Down here, we have a creditor applying to put in the provisional liquidators, and the company was saying no, we don't want you to do that. And this was an important part of the decision-making process that the funder had to go through, because as I say, the funder is not simply allowed to proceed with whatever arrangement it wants. The court has charge over this entire process now because of the appointment here of the PLs, and it needs to be satisfied, at least with respect to this company, and potentially now with respect to this company, that what is being done is being done in the best interest of the creditors. And so the funder has to weigh up, will that application succeed? What are the objections that are being made? Or will they succeed? And am I throwing money into this process, which certainly at this stage for the payment of lawyers' fees, the provisional liquidators' fees, and there were lawyers here appointed by the management of the company and by the liquidators. Is this a process that we ultimately are confident will succeed? And so that is a major potential roadblock. And you've seen all of the things that funders are looking for. The practical reality of trying to put in place funding in a scenario like this is that all of these pieces of the puzzle have to fall into place. Now, this is a relatively convoluted structure, and you referred to the priorities. That's absolutely right, that the waterfall in relation to each company needs to be taken into account. In particular, you had this issue that the funder did not want to fund here. The funder needed to fund here and had to take out at least some of its success fee in due course from this part of the structure, because this is where the sale proceeds would be ultimately coming in. And so it would not be financially viable for the funder to take its payment at this level of the structure. However, it needed to be sure that there would be some proceeds here in order to pay the service providers of this company. And so that presented its own complications and roadblocks. And so what we see is that on paper, if you were to take the mere fact that there was interest and that based on the balance sheet of the company, of the consolidated balance sheets of the group, actually there was more than enough value to repay all of the debts. It should just be a case of working through the process, and everybody would get paid. The creditors would actually have been paid, we think, 100 cents on the dollar in this case, and so no room for complaint. But you have to factor in different parties' motivations, impatience, appetite for risk, and even personality clashes in some cases between management and service providers or professionals or the lenders. And so you have to remember that we are always, although on paper we have one view, and that's usually based on numbers, it's ultimately based on headroom, financial statements, where we think the break is, how easy it is to hypothesize that there will be X% left over. But in the real world, the court has to bear in mind, and funders have to bear in mind, that you're dealing with different corporate strategies and different human individual personalities. And so from that point of view, it's not always a foregone conclusion. So there are a number of roadblocks the more involved the structure gets.
One of the things that I find very interesting about third-party funding as we go on reading and talking about it as like the next step and evolution in fund investment is the fact that you are waiting for everything to align. In insolvency and out of insolvency schemes of arrangement in India have always had a bad rep because you don't see too many of them happen on paper, but because they are essentially, M&A and not in contentious insolvencies. Everything is aligning in that deal, and that is something that one needs to kind of look at on a case-to-case basis, as you said. And maybe, just maybe, one of the things that can drive the agenda of third party for India, particularly in group cases where the debt amounts are very large, is the fact that you have a possible valuation which is higher because of the sector or the industry you're in, like the case of energy and gas exploration, or steel and energy in India, in the case of SR, for instance. Which brings us to significant question on cross-border, Mark. We've now looked at a local sort of setup where it is within Cayman Islands, and I don't want to kind of, I want to just talk about demographic and tell you that our population is much bigger in India, and where what people call a subcontinent with a lot of people and a lot of businesses. So in that kind of context, one of the things that has always been controversial is the setup of treaties and subscribing to protocols or governing international instruments, including the model law on cross-border insolvency. Now, does the model law for Cayman Islands provide assistance to third-party funding structures? I mean, how does it work if it was an outside Cayman case, but you have assets in Cayman Islands, or there's a creditor in Cayman Islands? What is the example there? And it is also very important and necessary for us as a jurisdiction. When I say us, I mean India as a jurisdiction, to understand, because we are looking at a need for group enterprise frameworks, and the UNCITRAL has recently released that group enterprise framework. Is there a structural framework, regulation, law on third-party funding in Cayman Islands, and how does it react to model laws and international instruments that I just mentioned?
Yeah, thanks, Ashana. That's really good questions. I suppose I need to take this two slightly different ways. The model law is very useful for Cayman practitioners, not because we have signed up to it, but because other countries have, and in particular the US. Now, you have to remember that everything we do in Cayman really is cross-border, and it's easier to take an example where the assets of the company are onshore, because that's almost always the case. The Cayman company will very often be an SPV, or special purpose vehicle, and the financing and so on will often be done through Cayman, but the assets will be onshore. Now, that's really helpful for liquidators and actually for funders too, because it gives the liquidators of a Cayman company the ability easily to be recognized in the onshore jurisdiction, let's say the US. That's very often the case for us. And to be recognized by the courts, and to be able to bring those types of claims that I was talking about, which often represent a significant proportion, if not 100% of the assets of the company. And so it's a very welcome development for liquidators, and in some cases directors, but usually these days it's provisional liquidators appointed by the court to be able to get Chapter 15 recognition in the US and immediately to have the protection that's given by the moratorium under that regime. So the company is not susceptible to claims by creditors. It's given the breathing space to be able to explore how to monetize its own claims. And so that's really important. And I'm involved on a regular basis with insolvent liquidation estates, where we look to funders, sometimes in the US, sometimes elsewhere, to come in on that basis, on the basis that Chapter 15 has already been obtained or can be obtained very easily and cheaply, because the center of main interest for the company is clearly in the Cayman Islands, and that there are good claims against defendants with deep pockets in the US. So that's the first part that I would say in terms of answering your question. We in Cayman don't have, we aren't a signatory to the model law, and so anybody coming in the other direction really needs to attain recognition the old-fashioned way, by which I mean common law recognition, and that's obviously doable. It's just slightly less it's less kind of by a formula, the same formula that you would use in any signatory state under the model law. But for us, it's more relevant, kind of outgoing. And then it's touching on your point about a group framework. I think that enterprise group framework is incredibly important. It's a slightly different point to the one I was just talking about recognition in an onshore jurisdiction. It's more, I think, as Untitled discovered, was that the existing model law wasn't really applying in all of the cases that it was hoping it would. And so more and more these days, big international conglomerates don't actually operate by individual entities in different jurisdictions in a nice, neat way. Very often you may have branches as opposed to subsidiaries. And the way that businesses are run these days don't always allow for clean-cut different approaches and recognition between companies. You're dealing with an entity which doesn't have only one home. One entity may have branches in a number of different jurisdictions, and so that complicates things. But there's no doubt that framework that has been put into place, it makes things much easier in terms of coordination and recognition, and that really is the name of the game for restructuring processes. Generally, the future of restructuring has to be the networks and the frameworks that allow not just lawyers, but particularly the courts, to appreciate and understand what is being proposed and how to make that universal recognition process as efficient as possible, because we're dealing with insolvent companies here and we can't be wasting money at every stage of the process. Now, it goes without saying that unless you're a signatory to those model laws, then they won't be directly applicable to you. And that's the case with the Cayman Islands at present, but we do have the benefit of them because we always deal with assets that are located onshore.
Now, one of the things that is obviously relevant for us to understand is the entire aspect of how a law has been brought about in a jurisdiction for third-party funding and how it kind of regulates itself, sort of. And where I'm getting at in terms of India, and when you're talking about recognition and regulation now for Cayman, which is essentially directed towards cross-border, is when we're talking about Jet Airways with Rob on Saturday, we just about skimmed over and said that, yeah, there is a protocol in place and we're looking at restructuring where there is money that is coming in different pockets, and there are different kinds of restructurings that are happening within a broader big umbrella. There is no choice of law yet. in the protocol. Yeah, we don't know what the governing law is, which is why the title of that lecture was No Rules, No Worries. Could you just give us a snapshot of what is it this new third-party funding law is looking at? And I understand that it is going to come into force quite soon.
Yeah, the Cayman Islands funding, third-party funding law. Well, actually, it goes further than third-party funding. It's really about litigation funding generally. It's not quite on the point that you've discussed about how to find the applicable law in an international group restructuring context as such. But what it does allow, going back to the roadblocks that we touched on a moment ago, is it might potentially take away a significant roadblock, because in an appropriate case, I mean, it will allow lawyers based in the Cayman Islands for the first time to be able to take on cases and fund cases themselves, by which I mean not ploughing in cash, but giving their services, and instead of being paid on an hourly rate basis, to agree to be paid similar to the funders on the basis of a success fee from proceeds. Either that arrangement, which is typically known as a contingency fee, or a conditional fee arrangement, which is an uplift in fees. So instead of, so on the basis of a successful case, having originally been paid either nothing or a percentage of an hourly rate, to then get an uplift. So your total consideration, if successful, is more than your normal hourly rate, maybe 150% or up to 200% of the normal hourly rate. And so what that does, I think, is, if you remember, we talked about a cautious approach based on the merits of an application to court, based on the merits of the restructuring generally and opposition. A lot of those factors are difficult for funders to get comfortable with, because they're looking at the case for the first time, whereas the lawyers involved may well have been involved in this case for any length of time, very often at least a year. So they will know the ins and outs, they will know the difficulties, and they may be prepared to take on that risk themselves. The other aspect is that I think you touched on it, which is incredibly important, that any funding, third-party funding arrangement in Cayman needs to ensure that the funders have no element of decision-making power over the course of the litigation. That's a really, really important part, and it's one of the main reasons why the court has to approve funding arrangements, because the moment that the funder has control over the litigation, it's subject to a conflict of interest, which cannot fit right for the benefit of the stakeholders. And so you don't have that problem where you continue to have the same lawyers advising the liquidators, because the liquidators remain in control at all times. And the new funding arrangements that will come into force, or should come into force, we think quite soon in the Cayman Islands, may help with that roadblock as well, because the court will simply be approving a process, or may not even need to have court approval for the process, which is essentially a continuation of the same parties. So that may be something which cuts down on the obstacles to allowing insolvent estates to actually get value for their assets, and it may be something in particular that allows access to justice for a number of plaintiffs who simply don't otherwise have the ability financially to proceed with claims.
What I find very appealing about this entire aspect of third-party funding is that the multi-stakeholder view that is taken. You're not just fixating on creditors as a part of the restructuring or the litigation setup. You're looking at a multi-stakeholder dimension, and I think that will be, if they're not already curious after listening to this conversation, there will definitely be some amount of sort of insight on why this might become a necessary tool for insolvency going forward 25th March onwards, actually, for India, because when we were chatting, I told you that we're presently a law in suspension for new filings or initiation of claims, and this has happened last March 2020, when we basically shut down globally. So it might be very interesting to see what the next step is. Much conversation has been happening on wanting to push for restructuring, but it may not be the case. And unlike Singapore, we might be in a situation of higher liquidation. So that's something we have to see in the next week or so, Mark, for India. And since I've raised the COVID angle, what was the COVID sort of setup in terms of insolvencies in the Cayman, and in terms of third party and business? Do you anticipate post-COVID there being more traction to third party? Is there a related consequence?
Yeah, thanks. Actually, just before I come on to that, I want to just clarify a point about the multi-stakeholder approach. I don't want to give the impression that the court will give equal weight to the views of shareholders and creditors in an insolvency context. It won't. It will favor the views of the creditors, and that is very important. But in those, well, I was going to say rare situations, but the ones I see tend to be rare, where you might have a surplus of funds left over, so you can pay creditors 100 cents in the dollar and still have something left over, at least based on your balance sheet. The court will take that into account, and it will allow shareholders to be heard, which I think is the point you're making. It is very important. But the primary, so that the insolvency practitioners owe their duties as directors do to the company. And that means that in an insolvency context, they will take into consideration the views of the creditors, and they will be paramount. But to the extent that it is likely, or it is possible, that there may be a surplus, then that's when the views of shareholders may be taken into consideration. But on the COVID point, it's an interesting question, actually. It doesn't really affect us directly now. Our court has adapted very well to dealing with things online. So we have Zoom hearings, and in some cases, that we don't have any advocates traveling now. We're used to instructing Queen's Counsel from England very often, and where that still happens, but they appear over Zoom or some other video link. So that's one aspect which has actually been relatively pain-free for us here, and judges have adapted to that very well. We are now starting to go back a little bit more to court hearings in person, but that's because of our fortunate circumstances here in the Cayman Islands, and I hope I haven't just jinxed that, but hopefully that will continue. But what I think might be interesting for funding is that what I think everyone around the world is seeing, perhaps as a result of COVID, is that there is a lot of capital ready to be invested. And I'm hearing a lot about distressed assets funds in the US, for example, and around the world. That's not an unusual thing for us in Cayman. We see that quite a lot, but I think at this kind of point in an economic cycle, we expect to see a lot more capital being deployed in different ways. And funding itself, as well as being an opportunity for those in charge of insolvent companies to be able to realize their assets in the form of claims or to explore restructurings, is in itself an investment opportunity. And it's a very attractive investment opportunity because the upside is usually relatively large. I mean, the success fees that we talked about are usually, or very often, in the range of 30%, sometimes more, of the proceeds of claims. And it's also a really good opportunity for the larger funders, at least, to be able to diversify, because by taking on a portfolio of funding claims or risks, the risk of any one of them is decreased. And so very often you will see funders looking to approach things and deploy sufficient capital in one go or across a series of claims, that what they're doing is creating an asset class which is sufficiently diversified and sufficiently profitable that they're able to attract large amounts of money, which is ultimately good for creditors in insolvent companies as well.
That's a lot to kind of take away from, Mark, because one of the aspects of this conversation that you and I have had is sort of an amalgamation of restructuring, refinancing, and also litigation, which is typically kept very separate from each other, starting with law firm practices. But there's an amalgamation of that in this conversation that you and I are having. Now, with that, I think we have a lot to think about in India, particularly on how funds and third-party funding arrangements can become a very significant part of insolvency and stressed asset recovery, because while it may not be, the myth of only India has non-performing assets might be bust-worthy, but it is quite high, particularly in the public sector and public sector banking. So I think this was a very relevant conversation and a very relevant time to have this conversation. And obviously, like I said, when we started, we looked to Cayman to do it first, come out of it, and then we'll implement it. So with that positive thought of waiting to watch what the next step in Indian restructuring is, and also the new commencement of the new funding regime in Cayman, I want to say thank you to you and wrap this conversation up. Otherwise, we'll be here your entire day chatting. And to my audience, I want to say, as I sign off, we're real-time responders of emails. So feel free to write to Mark, feel free to write to me. The only thing I'm going to request you to not do is badger Mark for lectures, more lectures. Please badger me so that I can petition him accordingly and bring him to the law school, and perhaps when lockdown lifts, we can do this in person and have a longer conversation. So with that, I want to say thank you very much. I want to say we have one more lecture left, which takes it a step forward to schemes and pre-packaging, which is the most relevant aspect of the insolvency law in India right now, and where that definition is complicated is what we're going to talk about tomorrow from an Australian perspective. And lastly, thank you very much, Mark Rakesh. I hope to have you again and again every semester, and I hope that we've not bored you to death at 8 a.m. your time.
No, thank you very much. It's been a real privilege.
Thank you. Goodbye.